Good afternoon. Good afternoon. So dark papers in the chairs. Move forward. We have plenty of seats up front. I like what this gentleman over here said. If you sit up front, you get the knowledge, the information quicker. Is that what you said? Okay. And what's your name? Bob Gosby. Okay. Follow his lead. Follow his lead. So we're going to go ahead and get started. We're going to go ahead and get started. My name is Donna Marshall. I am the Chief of the Employment Investigation Division, and I want to welcome you all to our civil rights training here in hot New Orleans, Louisiana. With me today, I have my colleagues, Candace Glover, who is the Chief of the Conflict Complaints Division, Crystal Gist, who is the Team Lead for the Employment Complaints Division, Cyrus Salazar, I don't know what division he's in. He's from the ADR, Employment Early Resolution Complaints Division. And we also brought our colleague with us, Cinnamon Butler, who is the acting chief for the Program Adjudication Division. If you weren't here this morning, you missed Dr. Leonard, who is the Assistant Secretary for Civil Rights. Yeah, you just missed out on that. I don't know what to tell you. We had a lot of technical difficulties this morning. We're not going to have them this afternoon. Unfortunately, it's after lunch. We're going to try to keep you all alert and awake. It's cold in here, so that should keep us alert and awake, if nothing else. In your chairs, you will see a handout that has some fact sheets on it about who we are and what we do. There's also an evaluation sheet. We would appreciate it if you would complete it. There is a box in the back of the room for you to drop the evaluation sheets in, or you can feel free to drop it off to Darvin Bennett. What's going on back here? We want to know what's going on. What y'all talking about? Okay, so this lady told me this group right here, y'all need to move forward. No, just kidding. There's an evaluation sheet where you can either drop it off in the box in the back, or you can take it to the Civil Rights Office and leave it there. So what we're going to talk about today is EEO awareness training for employees. And we're going to go over our training objectives are the common EEO issues, the overview of the EEO formal complaint process, as well as preventive strategies going through the complaint process as well. Part 1 is our common EEO issues, dealing with harassment, reasonable accommodation, and reprisal. I'm going to turn the mic over to Candace Glover and Crystal Gist.
Okay, good afternoon, everyone.
Good afternoon.
Just a few things. One, like Donna said, it is so hot, but you guys must have the best air conditioning in the whole wide world. It just saved me from buying some cookies for sugar after lunch, and I think this cold is going to keep me awake through the rest of the afternoon. Another point, just again, for you all sitting in the back, the slides may be a little hard to read. The slides are going to be available to everyone through your Civil Rights Office. After we present, we'll do our best. For the folks up front that can see them, bear with me. I'll probably read a fair amount of material that's on the slides so that everybody is on the same page. The third thing is we have a lot of material to get through this afternoon. We hope that it's going to be engaging, but we are going to ask that you hold your questions to the end. We plan to present for about 90 minutes, but then give adequate time for everyone to ask questions, for us to have a discussion, back and forth discussion and so forth on any issues that may come up during the training. So with that being said, I'm going to get the ball rolling here. So part one, I'm going to go over just a few of the most common EEO issues. So these are things that we see coming up most often in the complaints, the formal complaints of discrimination that come to the department, to our offices, and then also that in talking to your civil rights folks here at NFC, that they've been raised here at the agency. The first one is harassment. And harassment is defined as, or what it is any unwelcome verbal or physical conduct based upon one or more protected bases, I'm going to come back to that, that is so objectively offensive as to alter the conditions of an employee's work environment or employee. The conduct is severe and pervasive, and it creates a hostile work environment. Let me back up a second and touch on one point. Okay, so it's unwelcome verbal or physical conduct. Verbal, when I say verbal, I mean oral, and it can also be written. So any type of communication in that form. It's based on a protected basis. We are here, we're talking about EEO law. So I'm going to ask you, first question of the afternoon. What is protected, what are your bases that are protected under EEO law? Anyone? What can, if I file an EEO complaint, or if I want to complain about EEO, what are the things that someone's treating me differently because of my what? Race. My race. What else? My age, my gender, my sex. Religion. I'm going to come back to that one. Religion. Sexual orientation. Sexual orientation. I'm going to hit that one again. What else? My ethnic, my national origin. I'm going to throw out color. It's a little different from race, but it's race and color. We talked about age. Somebody said age, right? What else? One more big one. My disability. Thank you. Those are protected. Those are specific. Those are under statutes. We have the Civil Rights Act of 1964, Title VII. We have the Rehabilitation Act, which protects us as government employees against discrimination based on disability. We have our Age Discrimination in Employment Act. And then we have bases that are protected under executive order. And those things are, anybody have any guesses on those? What happens in November? The election. I can't be discriminated against because of my political affiliation. As part of a family, I can't be discriminated based upon my familial or parental or marital status. Coming back to sex. Sex now, I'm sure everyone's aware that it's kind of widening what falls under sex. So when we talk about sex discrimination now, we're not just talking about gender in terms of male, female. Sex includes discrimination based on pregnancy, based upon sex stereotyping, gender identity, and also sexual orientation. So it's kind of, that definition has been widened. So when we talk about harassment under Title VII, under EEO law, we're talking about harassment on those bases. Can there be harassment in the workplace that does not affect any of those protected bases? Can you be harassed and it not be based on your sex, age, gender? Absolutely. There is the Secretary has released an anti-harassment policy, and it says that there's zero tolerance of harassment of any kind. We're just talking about this specific kind here. Now, going back to harassment or hostile work environment, 3 key points about harassment. It's severe, it's pervasive, and it alters the terms of one's work environment or one's employment. What does that mean? Pervasive means it happens a lot. That's one of the things, it's the frequency. It's severe. That means I'm offended by it. It's offensive. Now, everybody has different levels of offense. So how does that play out? When things are very severe, So if someone uses a racial epithet, somebody calls someone an N-word, that's pretty severe. Everybody knows that that's shocking, especially in the workplace. But if it's a situation where my supervisor, who's male, every now and then happens to call me honey or sweetie or something along that line, that may still be offensive to me, but in terms of severity, it may fall a couple of notches down from the N-word. Severe and pervasive work together. They're on a seesaw. If something is really severe, it doesn't have to happen that often for it to constitute harassment. If it's not so severe, but it happens a lot, then it happens a lot. If he's calling me honey instead of my name or sweetie, and all my other coworkers, my male coworkers, he calls them Mr. Jones, Mr. Smith, and so forth, then that's a problem, that's harassment. So they work in tandem. The last point is, what do I mean by it altering my work environment? Has it affected my behavior? Has it affected my work habits? Is there a coworker that tells off-color jokes in the cafeteria to the point that I don't even go there anymore for lunch? That is, when we talk about altering your environment, those are the things that we talk about. Harassment is viewed from a reasonable person standard. So again, like I said before, we all have our different levels of what's offensive. When we get it, or when a harassment claim is looked at, it's looked at from a reasonable person. Would a reasonable person in that same situation feel the same level of offense as you would if you're making that complaint? One more, go back. The last point about harassment is it's not just simple teasing, it's not just offhanded comments, and it's not isolated incidents. It's something, again, severe and pervasive. So, next one, reasonable accommodation. Just a few key points about reasonable accommodation. Number one, first and foremost, you all at NFC have a reasonable accommodation process for requesting for individuals with disabilities. It's handled by your Civil Rights Office. If you have questions about specifically how that process works, please consult with your Civil Rights Office. I'm just going to cover just some of the main points that we all need to be aware of. Number one, there is an interactive process between management and an employee when an employee requests a reasonable accommodation. So that means that you should be involved and management should be involved in working out what your accommodation is going to be. Under the Rehabilitation Act, an employer is required to provide a reasonable accommodation for all known physical and mental limitations of a qualified individual with a disability, unless doing so will create an undue hardship. 2 points I want to make. One, known disability. That means that your supervisor or management needs to be aware of what the disability is. So that's a key point. So when you enter into a reasonable accommodation request process, that disability has to be known in order for it to be accommodated. 2, the individual has to be qualified. That means that as the person making a request, you are able to perform the essential functions of your position with or without the accommodation. So an accommodation, again, is just a change in the work environment that enables that individual with the disability to enjoy equal employment opportunities, able to perform their job. The requirement to accommodate applies to only qualified individuals. That's why I stress that. When you are in the interactive process, when you are discussing accommodations, it does not mean that as an employee, you get the accommodation of your choice. It means that you get an effective accommodation. I'm an individual with a disability. I actually have a bad back. I've had 2 surgeries and so forth. I need to have an ergonomic chair. I go to my supervisor, I tell him, or I speak with the disability manager, I tell them what my disability is, I tell them I need that, and I actually tell them I've already picked out what I want. You see, Lazy Boy has a special chair. It's a Lazy Boy 3000. It comes with speakers. It comes with a cup holder. It comes with massage functions, so that right around now, in about an hour, I can hit that button and keep working and have a nice massage going and that type of thing. I take it to my supervisor. We're engaging in the interactive process. I hand the paperwork in. I show them that, and they look at it, and they say, well, Crystal, we definitely need to accommodate you. We want you to do your job, but we're looking more at the Lazy Boy 1000, because the 1000 serves the needs that you have in order to make sure that the chair is properly ergonomic, but it doesn't have all the bells and whistles that, as the employee, is what I picked out specifically. So that's the main point that I want to make about reasonable accommodation. Go through the process, make sure both management and you are both aware that it needs to be interactive. Okay, last point. I'm just hitting these. We're gonna hit it and move on. The last one is reprisal. Reprisal is federal EEO law. All of the laws that we talked about, that cover all those protected bases that we talked about, they all have a provision that says it is illegal to take reprisal or retaliatory actions against an individual who has engaged in protected EEO activity. So, you can't be fired, demoted, harassed, or otherwise retaliated against for participating in protected EEO activity. What is protected EEO activity? The statutes define it as two different things. One is opposition. An individual has opposition, protected activity occurs when an individual has implicitly or explicitly communicated that an employer's action was or is discriminatory. Participation is more known is when an individual has either filed a complaint, testified, participated in an investigation, a proceeding, a hearing, any type of litigation that falls under the anti-discrimination statutes. So, 4 scenarios. You tell me if it's protected activity. Number 1, I testified in my coworker's EEO complaint. I provided an affidavit about what I witnessed as her coworker. Is that protected activity?
Yes.
Yes. Okay. I participated, my coworker, there was actually a misconduct investigation in our unit for one of my coworkers. I provided an affidavit, and in my affidavit, I mentioned that, well, this person may be doing these things, but it's because he's a male, he's the only male employee, and he gets treated better than me. He gets to go on trainings, he gets better opportunities to do details. The supervisor treats him differently and treats him preferentially because he's a male. Is that protected activity? How many people say yes? How many people say no? How many people are undecided because it's after lunch? Okay. It is, did I make a complaint of discrimination? Did I make a complaint about differential treatment? Did I complain about that in my statement? Did I complain about it being based upon one of the bases protected under the anti-discrimination statutes? Yes. Yes. So even though it's not in an EEO setting, even though it's not an EEO complaint per se, I participated because I've told my supervisors, I've told management, I'm being treated differently. So even if I walk into my supervisor's office and I complain that you're not giving me time off, I've practiced this religion, I need to be off on these days because I need to go to services, and I'm asking you to accommodate my schedule, and my supervisor says no, that is protected activity, because I've gone in, I've complained that I've wanted some type of religious accommodation, and it was not granted. Third scenario, I requested a reasonable accommodation. Is that protected activity? For my disability? Everybody's like, how many people say yes? Okay, more people, yes. So that's under a different statute. That's not, it's under the disability statute. So yes, it is. Fourth one, I filed a negotiated grievance. I was denied a promotion, and I filed a negotiated grievance. And I said the reason that I was denied my promotion was because of my age. I'm over the age of 40, and I was denied this promotion. Did I participate in protected activity when I complained of my non-promotion based upon age in the negotiated grievance?
Yes.
Yes, okay, definitely more. So yes, so my point is that it doesn't have to just fall under the EEO complaint process for it to be deemed protected activity. It's opposition and participation. Okay, so we're already through part number 2. Look at the time go. So those are just 3 main things, just 3 key points, and we're going to see these later on. We have a couple more scenarios coming up. What I want to move to now is talking about filing complaints of discrimination and what really happens when you file. To give a little background, to start off a complaint, you actually start off here at the agency, here at NFC. You feel that you've been discriminated against. Something has happened, a denial of promotion, let's say. I'll stick with that one. From the date of that action, I have 45 days to walk into or to contact my civil rights office and tell them I believe I've been a victim of discrimination. I initiate a complaint with them. That's considered the informal stage. What the agency civil rights office will do is they'll attempt to try and resolve the complaint here. And that will be based upon your election through traditional counseling where they get information from you, they get information from management, and try and work out a resolution. Or you can participate in alternative dispute resolution to attempt to resolve the complaint. Cyrus is going to talk a little more about that later on. If your complaint is unable to be resolved at the informal level, you receive what's called a notice of right to file. In that letter, it tells you, okay, you can, we were unable to resolve your complaint. You can now file a formal complaint of discrimination. Here's how you do it. And the main point is that you file it with my office, the Office of Adjudication. It comes to the Employment Complaints Division. You must file your complaint within 15 calendar days of receipt of the NRF, of the Notice of Right to File. Your complaint must describe the personnel action, policy, practice, or decision that underlies your complaint. So basically, you need to write in and tell us what happened. Why do you feel discriminated against? The complaint should be limited, or must be limited, to what was discussed with the EEO counselor. Because we get a report from them that also talks about how they attempted to resolve, what your issues were at that point. If there are things that have happened subsequent to you talking to the counselor that are related to the promotion, the issue, the non-promotion, if they're like or related, then you may want to, you can add those in. The complaint must be written and it must be signed. And then it must be sent to us, and we take them by mail, fax, email, smoke signals, so forth, but we need to be able to read it. It needs to be written and signed when it comes in. One little caveat I add to this is if you're sending something to us, make sure you send it in a way that you can verify that it was received, or you can track how it was sent. We it comes up to Washington, and every now and then things kind of go astray. Well, a number gets flipped, something along that line. So if you know I sent it on this date and I sent it to here, then it helps us in case that issue comes up. Unfortunately, it does happen, not that often, thankfully, but I just ask that on the basis, on behalf of my office. So what happens after you file? as I stated, it comes to my office, the Employment Complaints Division, and we do two important things. We acknowledge that we received the complaint, and we analyze the complaint, we go through it, and we determine what's going to be accepted for investigation. The key thing about the work of our office, or the key thing about a formal complaint, is that our work with that complaint is pursuant to a statute. It's under federal regulation. If you want to understand anything that I talk about this afternoon, you can read it through and find a basis for it in the Code of Federal Regulations, 29 CFR Section 1614. You can also go to the EEOC's website, and they have a management directive. It's Management Directive 110. That explains the entire complaint process from A to Z, from nuts to bolts. So, all of this information that I'm talking about this afternoon falls under 29 CFR and MD 110. So, when I say that we now acknowledge the complaint, we don't just simply, if you email it in, email you something back and say, got it, thanks. We actually have, by regulations, we send you a letter. The letter tells you a few things. One, that we received it, so we acknowledge receipt. Two, that the date that we consider it filed. It tells you that we now have 180 days to investigate your complaint, that you have a right to seek a hearing at the EEOC after 120 days, even if the investigation hasn't completed. The name and address of the EEO office, should you choose to request that hearing, the office that you need to make that request to. And then the fact that once we make a final action on your complaint, you have the right to appeal again to the EEOC, to their Office of Federal Operations. All of that is in writing, and we send it out to you certified mail. And that happens probably within 24 hours of us receiving your complaint. Thereafter, what we do is we analyze the complaint for acceptance, for investigation, or we dismiss it. A few key points about that. Not every complaint is automatically accepted. Every issue and every claim will be analyzed, and I'm going to go into that a little more in the next slides. When I say that it has to be analyzed, or we accept it, we do an accept-dismiss analysis. I tend to think of our office is kind of like the doorman to the EEO complaint process. It's a door. We're standing here, there's a threshold. We're just making sure that your complaint steps over that threshold. It's a minimal requirement. We don't look at the merits. When your complaint's accepted, that doesn't mean that you've prevailed. It doesn't mean that we've looked and we thought that you had a persuasive case. It simply means that you meet the statutory regulations of filing a complaint. We can fully accept your complaint, which means we accept everything you complain about. We can partially accept it, which means we're going to accept some things, we're going to dismiss some of your issues, or we can fully dismiss your complaint. If we partially accept your complaint, the claims that we dismissed, they can be appealed at a later time. We in our office when we identify allegations that are not going to be investigated, we have to, in that letter, explain to you why they're not being dismissed. Your letter actually becomes part of the complaint file. So that means that that letter goes to you, the investigator, the EEOC, the adjudicator, if it's a final agency decision. So our explanation for how we handle your complaint has to be on the record so that everybody's on the same page as to why we did what we did. If the complaint's dismissed in full, we give you your appeal rights. You have 30 days to file an appeal with the EEOC. Okay, so let's talk specifically. I'm going to get into the nuts and bolts of exactly what dismissing or accepting a complaint involves. My authority, I told you what we do is statutory. My authority to accept dismiss is under 29 CFR 1614-107. That statute specifically lays out 14 grounds under which I can dismiss a claim or a complaint during the EEO process. As I stated, these things, I'm going to run through them, but they're jurisdictional in nature. That means that they don't make any determination as to the merit of the complaint. So what's the first procedural thing that we look at? We look at time limits. We look to see whether you've met deadlines. So in all the talking that I just did, I gave you 2 timelines. Number 1 was when you need to contact an EEO counselor if you feel you need to be dismissed. How many days after an action occurs that you feel may be discriminatory, how many days do you have to contact your civil rights office? 45 days. Once you go through counseling and you get an NRF, how many days do you have to file your complaint? 15, right? Somebody said 30?
No, he said calendar.
15, oh. And look, that was gonna be my 15 calendar days. Okay, so if those aren't met, simply we count days, we look at dates. If they aren't met, we can dismiss either a claim, or if the complaint is not filed timely, we can dismiss the complaint.
So let's look at a scenario to see if this is really sticking with you guys. You guys look a little bit tired. Do you want me to stand up and, no? You just want to, okay, let's go through it. All right, we have scenario 1. We have 2 employees, Miss Not So Nice and Mr. Won't Back Down. They are colleagues, they are co-workers in the financial monitoring division, and they got into a physical altercation at work. After a brief investigation, supervisor issued Ms. Not So Nice a letter of reprimand. She issued a letter on March 12, 2015 for her involvement in the altercation. Mr. Won't Back Down was not reprimanded. Feeling she was a victim of discrimination, Ms. Not So Nice filed an informal EEO complaint against supervisor on June 12, 2015, alleging discrimination based on sex. Informal attempts at resolution were unsuccessful. And Ms. Not So Nice was issued a notice of right to file a formal complaint on July 12, 2015. Ms. Not So Nice went on a pre-planned European vacation and did not file her formal complaint until August 12, 2015. Everybody got it? Okay. Will Ms. Not So Nice complaint be accepted for investigation? No. This is a good crowd. Next question. I don't think they ate. If not, what are the bases of dismissal? All right. Who thinks it's both untimely and EEO counsel contact and filing? No?
Both.
Is everybody saying both?
Yeah.
Oh, really? Wow. Okay. You guys are right. It is both. Much better. Okay.
Okay, so that's the first thing, time limits. So the next set of dismissal bases that we have, or that we look at, is under the thought or under the belief that the EEOC does not want to have issues re-litigated or litigated a number of times in a number of different places, so it limits that. The first one says that if you've raised that claim in a prior EEO complaint, you're raising the same claim, and I mean it has to be the identical claim, same date, same person, same place, same claim, then it's dismissed. With that, again, I'm going to take my non-promotion. If I walk in and I claim that my non-promotion, my complaint was that I was denied my promotion based on my sex, and that goes through, maybe I didn't prevail, and after thinking about it, I go, wait, it wasn't sex, it was age. And I try and go back and refile a second complaint, or I raise the same non-promotion and file a second complaint just based on age, it's going to be dismissed because it's the same issue. The EEOC's position is, if you thought it was sex and you thought it was age, you needed to raise, or perhaps the investigation, through the investigation, getting that information, you could have amended to add age, but you can't go back and continue to relitigate the same issue or raise the same issue. The same thing provides if it's been raised in another venue or another forum. So let's take my non-promotion again. I've gone through the EO process. I've now moved and filed a civil action, again on my sex-based claim. And then while it's in federal court, I decide, nope, it was age. I can't go back and file a formal complaint just based on age, because when we get it, we'll say, nope, that issue is actually in court, in a federal district court, it's being litigated. We cannot process another formal complaint. If it goes through federal court and the judge rules against me, I'm not happy, I decide I want to start another formal complaint on it, alleging a different basis. Again, that complaint's going to come to us and we say, no, the issue's been decided. You took it to court, the judge made a decision on it, you can't come back and relitigate it. If I raise an issue in a negotiated grievance, I may not be able to file for another formal complaint. So let's take my non-promotion, I file a negotiated grievance. I follow the negotiated grievance process. Negotiated grievances fall under collective bargaining agreements. I believe some of you may be bargaining unit employees, so you know that the terms of that fall under a CBA. In the CBA, there's a section which concerns the election of forum and discrimination complaints. And what the CBA will tell you and will tell me is whether or not you can raise allegations of discrimination in your negotiated grievance. If you can raise it there in the negotiated grievance and you filed that grievance before you filed a formal complaint, we're going to dismiss the formal complaint because, again, EEO's thought is it's one issue, should be one venue, should be one action. If the CBA says, well, no, we're not going to process allegations of discrimination, then you may file for that non-promotion, you may file a grievance, and then we'll look at that complaint of discrimination based on that. But it's covered by the CBA. The one important point to know with a negotiated grievance is if I just file on that negotiated grievance and I just say, I think it was wrong, I think the supervisor got it wrong, I'm filing a grievance, but then maybe 2-3 weeks later, I say, you know, not only was it just wrong, did he just get it wrong, but he did it for discriminatory reasons, and then I try and file a formal complaint, we're still going to dismiss the formal complaint if you could have raised the discrimination with the negotiated grievance. So it's important that if you're filing a grievance, if you're thinking that there may be discrimination involved, that you understand what your rights and your responsibilities are in filing that grievance versus filing a formal complaint. The next one issue, one adjudication or one venue is an appeal made to the Merit System Protection Board. Merit System Protection Board is another administrative forum, it's another board that deals with personnel actions. So those are the type of things, they have a very specific list as to what they cover or what they hear. So if you're removed, if you're demoted in wage, in pay, and grade, if you are suspended for more than 21 days, if your appeal of a within grade increase is denied, then you have appeal rights to the MSPB. The MSPB has its own website, mspb.gov, where it provides the list of the personnel actions that they make decisions on. If something happens to you in your workplace and it is covered by the MSPB, more than likely you're going to get a letter when that action happens that says you have the right to appeal to the MSPB and it lays out how to do that. So they're very specific, and they're usually actions that you receive something from HR or employee relations. The key thing here is that if you make an appeal to the MSPB on an action, then you then try and file a formal complaint, we again have to defer to the MSPB to make that decision, so we'll dismiss the complaint. You can raise allegations of discrimination in an appeal. So let's say I was removed. I file my appeal with the MSPB. The MSPB, if I decide that it was because of, I'm trying to change them up, because of my race, then I can state in my appeal to them, it was wrong, I feel that they didn't have the legitimate basis to remove me, and I feel that it was done because of my race. The MSPB will look at the action, they'll look at management's decision to remove me. There'll be an adjudication, a hearing on that, and they'll look at both the merit system protection, the merit principles behind that personnel action, as well as the discrimination. Once a decision is made there regarding the decision whether it's upheld, if it is upheld, then actually it can be appealed on, the decision can be reviewed by the EEOC to make sure that they got it right with regard to the discrimination. But again, if that appeal is filed, it goes to the MSPB, we'll dismiss the formal complaint. The last basis dealing with multiple filings is abusive process. Abusive process occurs when a complainant is using the system to file multiple filings, and I mean multiple filings, on the same issue, so they keep coming back, I got denied a promotion in 2008, and I have not let go of that. I am filing every year, every 6 months about that. I'm submitting information, or now I'm being very non-specific about what's happening. I'm not describing it. Or I'm just doing this as a retaliatory effort to kind of clog the system. That's it. That's all that I'm doing. I'm just submitting these. The complaint can be dismissed for abusive process. Abusive process actually is a determination a lot of times that doesn't happen in our office, but does at the EEOC. If the EEOC continues to get the same complaint from a complainant year after year, number after number, then they'll say, you're abusing the process, we're denying this complaint, we're putting that on the record. Is there a magic number for that? Absolutely not, because everything is looked at on an individual basis. So, glad to say it doesn't happen that often. We don't see that very often at all.
Let's do another scenario. Okay. Following another altercation at work, supervisor suspended Ms. Not So Nice for 21 days. Ms. Not So Nice appealed the suspension to the MSPB and also alleged discrimination and harassment based on reprisal. Later, Ms. Not So Nice filed an EEO complaint alleging discrimination based on sex, harassment, and reprisal when she's suspended for 21 days. What do you think is going on here? Will this complaint be accepted?
No.
Somebody tell me why.
Any different complaint.
I can't hear you guys. You said no, same claim? Is that it? Anybody else? Same action? Let me go back to it. So I said she went to MSPB. You see? So the same, but she filed the claim at MS, so that's why it won't be. Should any of her complaint? Oh, okay, so you guys say yes, it should be dismissed based on that. Okay.
Okay.
I think I can answer.
Okay. Okay. So the third category of dismissal bases actually deal with the content of the complaint itself, or the content of the complaint. The first basis is failure to state a claim. Failure to state a claim is defined as a loss or harm to a term, condition, or privilege of employment. Can someone tell me or give me an example of what a term, condition, or privilege of employment? What is it?
A term what?
Your time,
No, I didn't hear your term, what you said?
term, condition, or privilege of employment. Any benefits?
Let me give you an example.
Well, yeah.
Is telework a term, condition, or privilege of employment?
It's a privilege, right? What about, but you, this is NFC, something that I love that you all do every 2 weeks. I get paid, yes indeed, I love that, that's a benefit of my employment.
Term of employment.
What else?
Trainings.
Training is a benefit. No? Someone said no, it's not? Yes, it is.
It's a benefit. Yeah, right.
Leave, somebody said leave. Leave is a benefit of employment. So, anytime there's a harm or a loss to one of those benefits, it's considered, it states a claim. If you believe that the loss of that privilege is based upon a discriminatory basis, then it states a claim. 2 examples, and this is something common that we get. We get complaints that say, my supervisor rejected my timesheet. Okay? We have to read the complaint to figure out one of 2 things. Did your supervisor go into the system and reject it and say you need to correct X, Y, Z, so you had to do that and you got paid? Or did they truly reject your timesheet and you didn't get paid? Which one is the harm or loss? Which one states the claim? When you didn't get paid, right? So those are things that we have to kind of figure out, that we have to read and we have to have the information in the complaint to figure out, because not getting paid is a serious matter for all of us, I'm sure. Okay. The next one is a preliminary step. The EEOC says that if a matter is an action is proposed, but it hasn't happened yet, then you haven't suffered that harm or loss to a term, privilege, or condition of employment. So, for instance, if I receive a notice of proposed suspension, it's stressful for me, it's upsetting, but have I been suspended yet? No. So according to the EEOC, according to that law, it's a proposed action. If I receive a letter of expectation, which my supervisor gives me, and basically says if I don't follow these things, if I don't do these things in the performance of my duties, I'm subject to discipline. A month later, after I didn't do some of those things, I get a letter of reprimand. Is the letter of expectation a harm or loss? Is it a preliminary step? It's a preliminary step to the actual letter of reprimand. So, those things on their own do not state a claim. We have to dismiss for that. The only catch to that is, if I filed an EEO complaint, if I participated in that protected activity that we talked about before, let's say I've testified in an EEO hearing that involved my supervisor, and a month later, my supervisor issues me a letter of reprimand, and I feel that whatever he or she's written up in that reprimand just isn't true, I believe that it's retaliatory for my participation, for my statements in that EEO hearing, then that does state a claim, because he may be trying to deter me from ever participating in EEO matters again. So, a preliminary step. We also can dismiss if an allegation is moot. And mootness is a kind of a tricky basis, a tricky ground. But what it is essentially is that the circumstances which caused your complaint, your allegation of discrimination, no longer exist, and that relief, the agency has provided sufficient relief such that it will never happen again. It will never, ever, ever happen again to you as an employee. The never, ever, ever causes the problem in using that basis, because, you know, we can't say for sure whether that's true or not. An example would be if we have a employee, this was a case, where an employee was denied access to the medical unit at their workplace. So he filed a complaint alleging disability discrimination. About a month later, that employee retired from federal employment. The only thing he asked for when he filed his complaint is that as an individual with my disability, I want to be able to go to the health clinic. He didn't ask for anything else. That was it. When his complaint came through, it was deemed moot because his access to that medical unit stopped when he was no longer an employee. So the relief that he wanted, the employer couldn't give to him, the agency couldn't give to him because he was no longer an employee. So it's when those circumstances are completely eradicated that an issue is moot. Not something that we see very often at all. The last round under this, in terms of content, is when you allege dissatisfaction with the processing of an EEO complaint. That's considered a spin-off complaint. The EEO process is statutory. The people that participate in it and that work under it are not. We're actual people. So sometimes there's issues. Sometimes you go to counseling and maybe you feel that the counselor didn't properly counsel you. Perhaps once your complaint is accepted and it's in investigation, you believe that the investigator has done something wrong. So you make a complaint actually about the processing of your complaint. The EEOC believes that we cannot, as the agency who's processing, or the office is processing your complaint, we shouldn't be able to resolve or to adjudicate complaints against ourselves. So what this basis tells us is, when those types of issues come up, agency, what you do is you take those allegations, you put them in the complaint file, and we'll do that when you write in and you tell us that you're dissatisfied, that you have an issue about what happened with your complaint. We notify the official that is in charge of that section. So if it's an issue with counseling, we notify the civil rights directors here. If it's an issue with an investigator, then we contact the investigations unit. If it's an issue with how we responded to your complaint, then it may fall on us, on my degree. What we do is we respond and we basically give an account of what occurred, what actions were taken, if there was an error or mistake, what we did to correct it, and we put that in the file. Those two documents go, when the matter goes to the EEOC, whether on appeal or at hearing, and the administrative judge looks at it. And they will decide whether in fact there was something that went awry, something that affected the processing of your complaint, and what, if any, further action needs to be taken with it. So, again, that's a spin-off complaint.
Another scenario. In June 2015, Mr. Not So Nice learned that supervisor did not select her for the promotion. Ms. Not So Nice is an excellent employee and received a superior on her last performance rating. However, Ms. Not So Nice is difficult to work with, and many employees have complained about her abrasive nature. Supervisor selected Mr. Won't Back Down for the promotion. Shortly thereafter, flyers were anonymously placed throughout the office, making fun of older employees. Also, retirement papers mysteriously kept appearing on Mr. Won't Back Down's desk. Mr. Won't Back Down is 66 years old. Several co-workers have informed supervisor that Ms. Not So Nice was responsible for the posters, but supervisor has not taken any action. Mr. Won't Back Down filed an EEO complaint against supervisor alleging harassment based on age. Does Mr. Won't Back Down state a claim? How many of you say yes? Everybody say yes. What's the claim? Based on what? All right, I'm gonna call you. I see you passionately saying something. What are you passionately saying to us? Who was harassing him? Who was the claim against? I'm asking who he be filing a complaint against.
It could be friends.
You
filed it against the supervisor.
is that the correct party to file against the supervisor? The supervisor didn't do anything.
I guess because the supervisor didn't do anything about it, even though they had been told.
What's your name, man?
Jerry?
Everybody clap and give Jerry a round of applause. Jerry. That's absolutely right. His claim would be against supervisor because supervisor has a duty to protect him from harassment in the office he's experiencing, allegedly, from Ms. Not So Nice. That's good.
That's good. Great job. Even after lunch, great job. Okay, so the last two bases that we look at in procedural dismissal or in the accept dismiss process actually involve in a complainant's participation in the process. And these two bases can happen at any time, not just at accept dismiss, but later on during investigation and even possibly adjudication. The first dismissal basis is when the complainant cannot be located. Sometimes after a complaint is filed, the complainant moves, transfers out of the area and so forth, but does not advise us of the change in their address or in their residence. Your acceptance letter and the regulations say that as a complainant, you have a duty to keep us informed where you are. If you do not, we have the right to dismiss your complaint. And the reason for that is that there may be times when, even at the acceptance level, we need to contact you. There's additional information that we need in order to make a informed or a proper decision regarding what claim should be accepted. This is especially important at the investigation level. If an investigator is trying to contact you and they can't find you, the investigation can't happen. So what happens is we attempt to contact you based upon the information you provided us. We typically reach back out to the agency, see if they have any updated information, but at some point we send a notice that tells you to the best address that we have or the most recent address that we have for you and states that we need you to contact us and advise of your proper contact information. If you have 15 days from receipt of this letter to do so. If you do not respond, we're going to dismiss your complaint. The regulations give us the authority to do that. Likewise, if there's a failure to cooperate, if in the midst of the process, we ask for information and either we know where you are, maybe we reached out, we responded, but then you get to the point where you're being unresponsive or for every question that we send you, you send us back 10 and you're being unresponsive. Again, a letter goes out and says, we've made multiple attempts, and typically we have, to get this information or to have you cooperate. If you do not provide us with XYZ, requested information, then we have the right to dismiss your complaint. So with that, it's just once you start in the process, please always keep us advised, stay involved. It's an ongoing process of investigation and inquiry, so we need to know where you are and that you're responsive. Now, after we get through those 14 grounds that I went through, and as you can see, it can take some time and there can be some issues that we need to work through. What happens is my division issues a letter of acceptance. That letter is addressed to you. A copy is provided to the investigator, and as I said, that it goes through the process, but your matter is then transferred to our investigations unit, and Donna's going to talk about what happens in that process and thereon. Thank you.
So the investigation process is a non-adversarial process. You are a federal employee, so you are obligated to participate in the process. If you leave USDA and you go to FDA, you're still obligated to participate in the process as a federal employee. If you serve as a witness, you are obligated to participate in the process. The complainant has identified you as a witness. Whether you have knowledge or not, you still must participate within the process. The agency is responsible for developing an impartial and appropriate factual record upon which to make findings on the claims accepted in the acceptance letter from the Employment Complaints Division. That's what the investigator is going to investigate. They have 180 days from the date the formal complaint is accepted to conduct their investigation, unless, of course, the complaint is amended, consolidated, or an extension has been granted. If the investigation is not complete within 180 days, the complainant has a right to request a hearing with the Equal Employment Opportunity Commission. What we will do is we will offer the complainant an extension. If they say no, we will issue them the 180-day letter. They can go ahead to EEOC and request a hearing. However, we will continue with the investigation until we have completed it, and/or EEOC requests the report of investigation. At the conclusion of the investigation, the complainant will be issued that report of investigation. You have 30 days to make an election as to whether or not you request a hearing from EEOC or whether or not you want a final agency decision, also known as a FAD, from our Employment Adjudication Division. Of course, those complaints that are mixed complaints, we process them within 120 days, and they immediately go to our Employment Adjudication Division for a FAD. The role of the investigator is to collect, discover, and present evidence related to the claim of discrimination. The investigator is a neutral party. They do not side with the complainant. They do not side with the agency. They don't represent anyone. They're just there to conduct the investigation. There are times when complainants say, I don't like my investigator, I want a new one. Well, you have to justify as to why you want a new investigator. We just don't arbitrarily change investigators because you don't like the person. There has to be something of substance. They're there to conduct a thorough review of the circumstances of the alleged discrimination, the treatment of the members of the complainant's protected class compared to those who are not in the complainant's protected class, and any employment policies and practices that are relevant to the complaint. They must also use any combination of tools such as interrogatories, which is where they submit the questions to you in advance. We only approve those interrogatories under extenuating circumstances. For instance, the Forest Service, they go out and fight the fires. Complainants and witnesses are not available to participate. So we do say, yes, go ahead and send them an interrogatory. There is a deadline as to when they have to send it back, but the investigation is still ongoing. Please hold your question until the end. If you could just write it down and I'll address it then. Unless it's a burning question and you just want to get it. Okay. The affidavits are the sworn statements that are sent to the complainant and the witnesses. You have an opportunity to review the answers to the questions that the interviewer has asked you over the telephone. That's typically how the investigator conducts the interviews. You review it, you can make changes to it. We ask that you sign and date it and send it back to the investigator. Again, there's a certain period of time in which you have to send it back. And in some cases, there are the fact-finding conferences. The investigator prepares the investigative summary, also known as the report of investigation, in which you have an opportunity to review it. Within 30 days, you can elect either a final agency decision, which is issued within 60 days of receipt of your request, again from our Employment Adjudication Division, or you can elect the EEOC hearing. The AJ will develop a record and issue a decision on the merits of the complaint. The agency may take final action on the complaint by issuing a final order within 40 days of receipt of the AJ's decision. Of course, if you're not satisfied with the agency's final action, you can appeal the matter to the Office of Federal Operations at EEOC, or you have an option of filing a civil action in district court. I'm now going to turn it over to Cyrus. He's going to give you all some information on ADR and mediation.
Thank you, Donna. Good afternoon, everybody. So we are in the home stretch. So thank you for your patience. How many of y'all have heard of alternative dispute resolution? And many of you have. And I've been in this field long enough to start calling it appropriate dispute resolution. So we have to manage conflict internally. We have to appropriately handle situations that arise in the workplace. So we want to transition and let you know a little bit more in detail about the role of ADR here in the federal sector. So what is ADR? Basically, it is an umbrella term that covers a host of techniques that we utilize as an alternative to traditional litigation. Many of you have heard of these techniques, and we're going to go through them in a bit of detail. And also, it is an empowering process because it gives you an opportunity to craft your own resolution, to be creative, to work alongside the other party at the negotiating table, to ensure that you have a process that is fair, impartial, confidential, and is designed to lead towards restoring relationships. Let's take a few minutes to look at some of the various types of offerings and techniques that we have. On the screen, and I'll read through them since some of you in the back might not be able to see them, is number one, conciliation. And we use conciliatory approaches, meaning the cooperative perspective, the collegial perspective to share information cooperatively to ensure you have an opportunity to address your concern. This is done with a neutral party. Anyone who is in the ADR field does not side with management, nor do they side with you as either the aggrieved party or the complainant. They are there as a neutral party. Secondly, in the realm of ADR, we see a lot of conflict coaching. And what we have noticed is some individuals are not prepared to engage in conflict. So if Cinnamon and I had an issue where she kept on cutting me off in staff meetings, and I took offense to that, and perhaps the first thing I want to do is just start arguing with Cinnamon and start yelling at her because I'm upset, because it's a credibility issue that she keeps on cutting me off. But I could go to the ADR office and I could sit down with one of the practitioners and they could coach me on how I could better interact with Cinnamon. Because guess what? We work with each other, right? If I go in there yelling and screaming and really upset, what is that going to do to our relationship? It's going to further worsen it, isn't it? But if I go in there where I've been coached, where I can articulate my perspective professionally, where I can look her in the eye versus having that vein pop out of my forehead when I'm upset, then it's gonna help lead towards a restoration. So ADR is designed to coach people on how to insert themselves in a professional manner. We also have facilitation. And facilitation is where you have a third party who is going to facilitate dialogue between groups. Because oftentimes, conflict is not between party A and party B. It's between party A and party Z and all the alphabet in between. So sometimes we need those mediators to come into the organization to help resolve some of the issues and some of the tension and some of the concerns. We also have shuttle diplomacy. For example, I might not want to be in the same room with Cinnamon because maybe I was really upset. So the neutral party could say, you know, Cinnamon, Cyrus is really concerned because every time you see him come into the elevator, you keep on pressing the door close button so you can't be in there together. And then she'll say, well, it's not that, it's because I cannot stand, he never brushes his teeth, he has really bad breath. So that other party could come over here and say, well, Cyrus, here's the reason why she's cutting you off in staff meetings. It's because she hates the color of your ties that you wear. And you never tie your shoes. So you see where I'm going? Sometimes timing is everything, and maybe the situation is at the breaking point. So we can shuttle that information back and forth. And it's all designed to encourage dialogue so they can resolve their concern. We also have mediation. Many of you have heard of mediation. This is at the bargaining table when you can be in there in good faith. You can have representation or not, or non-representation, but it's designed to give you the empowerment to seek and draft and create your own resolution. It can be on a variety of circumstances. We also have fact-finding, just gathering the facts and giving the perspective. We have that group dynamic problem solving, where there are some themes and some issues and some deeply rooted concerns that we go into organizations and help them thrive after that. We also have a few more that we offer that are at the formal stage, such as settlement conferences and the use of early neutral evaluators. But guess what? Here's the great part, is that utilization of ADR is for a variety of workplace purposes. It can be used through the entirety of the EEO process, whether it be at the informal stage or the informal or the formal stage. It can also be used more than once. It doesn't mean it's a one shot at this and you're done. Like they say in real estate, it's location, location, location. When we're trying to resolve conflict, it's oftentimes timing, timing, timing. Because if it's fresh on my mind, I might be really upset. Or maybe I'll go home and talk to my spouse, or talk to my dog, or talk to my colleague, or my confidant, or my coach. And maybe in a couple of days or next week, I'm more prepared to engage. The great thing is that it can be used also for administrative grievances. Because guess what, ladies and gentlemen? Not all workplace disputes and not everything that we deal with is discriminatory in nature. It has nothing to do with my religion. It has nothing to do with the color of my skin. But it has everything to do with a credibility issue when someone cuts me off at a staff meeting. Or when someone is doing something that's a credibility issue to me. That's why we have other processes or other venues that people can utilize to address their concerns. For performance appraisals, in the Department of Regulation, written in there is the use of ADR if someone feels they did not receive the appraisal that merited their work. Also for workplace disputes, which I just counted through, I imagine. And then lastly, through union negotiations, helping the bargaining unit rectify terms and craft terms and determine the outcomes of the bargaining unit language. That's what ADR can be used for. But check this out. The benefits of ADR are vast, but I have heard so many of the myths and so many falsities about ADR. I've heard that ADR is only for managers, and absolutely not. It is for every one of you, regardless if you're a wage grade employee, if you're an SES, a GS, whatever pay scale you're in, it can be used for a variety of workplace purposes. It is used on a daily basis, and I hope that you all understand that it can be used in a variety of circumstances. Here's some of the benefits. If you elect to use ADR versus traditional counseling, you have an opportunity to be empowered. You're the one who's at the driver's seat. You make the election to choose either venue, informal or formal, and you have control. The time savings are vast as well. Versus going through the lengthy entirety of the EEO process, you can elect to go to ADR, and hopefully you can negotiate a settlement that is going to work for you. Again, it's the compromise, it's the negotiation, it's identifying what's going to work for you. It's a structured process, but it's all based on solutions, looking at creativity, being flexible, and most importantly, it is confidential, because what happens in either of those settings stays there. That is exactly what ADR is designed for. So guess what? We have another scenario. Let's take a look at this scenario, and we'll be really brief. Or do we want to do the scenario? Okay, we'll do the scenario. So last night, David and Cyrus were out on Bourbon Street, having a good time when we came into town. And we were having the beads thrown, and we were doing all the fun, crazy stuff. So we came into work yesterday, and Millie, one of our coworkers, overheard David and I talking about our sexual exploits down on Bourbon Street. She took offense to this. We thought we were alone, but regardless, she took offense to our dialogue. She went and told our supervisor, Candace, and Candace pulled us aside and said, hey guys, look, she filed this issue, what are we gonna do? Candace goes and talks to the ADR office, and they give her the option. Out of those techniques that we talked about, what do you think would be the best technique to utilize in ADR to address Millie's concern? Anybody? And there was no right or wrong answer here. I'm sorry? Okay, perfect. Shuttle diplomacy could be appropriate for this because oftentimes when you talk about issues that are sensitive in nature like sexual harassment, people do not want to be in the same room because they took offense to that. So the neutral party could use shuttle diplomacy to shuttle information back and forth and let us know, hey gentlemen, this is inappropriate for us to use this type of language in the workplace. Let's focus on talking about the nature of the mission of our organization. Let's keep everything focused on work and leave that out of the workplace altogether. So that could be one of the outcomes. You can use facilitation to facilitate dialogue with the group. It's a variety of things that we can utilize. So we are going to wrap up now. Some food for thought that we want to leave you all with. Number one is, if you engage in the formal EEO process, you are entitled to a reasonable amount of time, official time, while you're on the clock for working to address the issues in your formal complaint. Secondly, you can be represented throughout the process. Some of you can retain counsel. If that's my mom, tell her I'll call back, please. Thank you, appreciate it. And then you must keep the agency informed about your address. This has happened before. If you move, your mail might not be forwarded. So make sure that the EEO office or the Civil Rights Office has your correct mailing address. Otherwise, information will not get to you, and guess what? Your complaint could be dismissed. Lastly, is that you have the responsibility to cooperate with the EEO investigator. If they call you, if they email you, if they send you an affidavit, make sure that you give them the information in a timely fashion. Otherwise, this circumvents the entire process because they're unable to complete a thorough report of investigation. Lastly, we encourage everyone in this room to handle problems at the lowest possible level, point to point, colleague to colleague. Otherwise, what happens? Those issues start to simmer, then they start to boil, and then we have an organization in distress. We need to have that dialogue face to face when Cinnamon cuts me off. We need to ensure that we empower ourselves to take action. Also, we've got to be problem solvers because not every situation revolving or involving conflict is the same. I cannot have a cookie cutter approach for everything that I do because the personalities are different, the moods are different, the issues, the concerns are different. So we've got to ensure that we are approaching everything with an open mind. Because oftentimes, we might think it's the obvious nail in someone's forehead, but guess what? There was so much below the surface. It's the hidden expectations. It's the other conflicts that we've had in the past. It's my hidden agenda. And the more that we understand, the more that we dialogue, then I'll understand that, that Cinnamon is different than me. She likes different music than I do. She likes her fish black and I like mine baked. It's the little things in the workplace that make a huge difference. It's also important that everyone in this room leads by example. When we talk about walking the walk and talking the talk, you've got to live the example. Because that is credibility, that's authenticity. This is how we ensure that we are... All right, let's go. That's a good one, all right. There was someone I was going to give a hard time to in the back there because they were playing too much Pokemon. I was like, hey, there's no Pokemon in this room. We're going to find it. But lastly is, when in doubt, if you have any questions or concerns, you all have subject matter experts here in your Civil Rights Office that you can count on to address the concerns and the issues that you have. All of us are resources that are available to you, but again, you have people on site that are here to serve you as well. So that is our time this afternoon, but we want to spend some more time with you and have some very candid feedback and some dialogue. And this is important. We want to understand your concerns. What questions do you have? And just be mindful that we're not going to share this with your leadership. This is for us to understand. Yeah, is there any managers in here? If there is, we would ask the managers to leave and everyone who's a non-manager.
Kindly ask all the managers and supervisors to please leave so we can have a candid conversation with them, please. Thank you.
All right, so we know, number one, that there was a burning question over here. I know we had one question we're going to address. Right? Come on down. I'll come to you.